guess, Mr. Liu, the question is, how does that really differ from Colesville? I mean, the problem that I think is sort of what is happening in your analysis is that you say that the Colesville conduct does not fall within the discretionary function exception, which seems to me to be a concession that even if we agree with you that these aren't in two separate categories, law enforcement and discretionary function, we still have to figure out how broad the discretionary function exception is, which is the question you say we're not allowed to answer.
The conduct in Collinsville flunks the first step of the Gaubert two-part test.
Is that the discretionary function test?
Yes.
All right. Well, so then we are having to assess the scope of the discretionary function in this conduct, in this context.
I don't think so.
I don't see how you can say we have separated that out of the question presented, we can't look at it, and you're still answering these questions in this way.
No, because I think this case comes to the court on the assumption, as the courts below found at 17 to 18A and at 58A, that the conduct here did satisfy Gaubert's two-part test. Now, the only out that petitioners have left then is to say that the proviso nevertheless removes those claims from the scope of A. That's what I took to be the threshold statutory question that this court granted cert to decide. If I may just address one point that my friend
I'm
raised.
sorry, counsel. You're doing exactly what the other side is doing. You are begging the question, which is how far does this discretionary exception goes. The other side wants an absolute rule that all intentional torts are not covered. You want the opposite, which is if there's any discretion in the activity, then no negligences or intentional actions are covered.
No, I don't.
The two of you are going into separate corners.
I'm not asking for an absolute rule. I'm asking for the court to just stick with its test in Gaubert.
Yes, because you got a great decision below, but is that fair?
Sometimes that test will result in the United States being exposed to liability. Sometimes it won't. It's not an absolute test. If I may just address my friend's suggestion that the proviso did nothing when Congress enacted it, we don't view that to be the case. Before the proviso was enacted, officers like Guerra had two layers of protection from liability. They had the discretionary function exception, and then they had an extra special layer of protection provided by subsection H, which gave the United States blanket immunity for any claim based on a particular type of tort. What the proviso did was remove that special layer of protection, but it left in place.
That is so ridiculous. Congress is looking at the Collinsville raid and providing a remedy to people who have been wrongfully raided. And you're now saying, no, they really didn't want to protect them fully. They were just going to take them out of that exception, but leave in the discretionary exception. I gave you discretion in Collinsville. The officers are permitted to break into a home if they think an emergency existed. That's why those officers did that.
Yeah,
they may have been wrong about the emergency existing. They may have been wrong about the warrant law. But under your test, it's their discretion to arrest when they think there's an emergency.
No. What we understand the proviso to do is to remove that blanket special layer of protection in H. That requires the U.S., in these types of cases, to battle it out under the discretionary function exception. And that's quite significant because there's a large set of cases that are going to flunk this court's two-part test in Gaubert, chief among them the raids in Collinsville. And so by removing the proviso...
That's right. Flunk it. All right. Thank you.
So by removing the proviso, it requires the United States to hash it out under the discretionary function exception. As I say, there are plenty of cases that are going to fall outside that discretionary function exception.